Hello, everybody. Thank you for joining us this evening, this morning, this afternoon. My name is Nicole Zafian, and I'm the head of content and education here at CLOC. We're thrilled to bring you today's Ask the Expert panel on alternative fee arrangements, and it can tell that many of you are excited. We have a great audience today with our presenting sponsor, PERSUIT. Before we get started, I just wanted to point out a couple of things to help you get the most out of today's session. So on your platform, you'll notice different boxes and tools. We have a chat feature, which we ask that you use for chatting with each other, sharing your thoughts, and responding to what you're hearing from the experts today. Then we have our Q&A box. So some of you have submitted questions ahead of time for the panel, but you can also ask some questions live. They'll take some time here towards the end to respond to live questions. So make sure if you have questions, go ahead and put them in that box, and our moderator, Maddie, will be monitoring that today. The slides that are going to be shared today will also be available as a PDF download in your resources box, so go ahead and grab those. And then finally, when we end our session today, you'll notice a session evaluation on your screen, so please take a moment just to complete those brief questions and give us some feedback on your experience with the session. We're recording today's session, so you'll be able to come back and rewatch it anytime as well. We'll send that link out tomorrow in a follow-up email. With that, I want to again welcome you all for joining us and thank our amazing sponsor, PERSUIT, for putting together this session. And I'll hand it over to Madeline.
Thanks, Nicole. So as Nicole said, I'm Maddie, Client Strategy and Success Manager for APAC at PERSUIT, and I'll be moderating the session today. PERSUIT is the first to market enterprise platform that facilitates a competitive process for sourcing outside legal counsel, which is saving our Fortune 500 clients millions per year. I'm super thrilled to be joined by David, who's our Vice President of Client Strategy and Success at PERSUIT. David focused his JD and MBA on the business of law and wrote a leading thesis paper on alternative fee arrangements under the direct study of Professor Kenneth Grady at Michigan State University College of Law. Before coming to PERSUIT, David led a program to implement AFAs and outside counsel RFPs at Johnson & Johnson. We're also joined by Laura, who leads up the global strategic sourcing team at PERSUIT. Laura works closely with lawyers of our Fortune 500 clients, empowering them to make the best possible sourcing decisions and harness the benefits of AFAs and legal engagement strategies. And we are also joined by Ryan, who's the Senior Legal Operations Manager at Stryker Corporation, who is a leading medical technology company driven to make healthcare better. Ryan has several years of experience in legal operations and compliance roles, and his current primary areas of responsibility include firm and vendor management, financial management, business intelligence, technology, and service delivery models for Stryker's legal and compliance department. So I'm excited to introduce our agenda today. We're going to be taking you through a jam-packed session. So David and Laura and Ryan will be setting the scene on the why and what and when of AFAs before we move to our moderated discussion. Thank you so much for your questions that you've already sent through during registration. We'll be addressing a number of those during the presentation, but please continue to ask questions throughout using the Q&A box. I can see that a couple of you have already started to do that, so we'd love to see it. David, I'll pass over to you.
All right, thanks, Maddie. So before we're going to plan on just covering a number of different AFA models, and there are some questions from the audience about what's the right AFA for a particular matter types. We had questions about what are good AFAs for intellectual property matters. So we're going to cover a number of those questions throughout the session. But just before we do, I wanted to start by just discussing why is it even important to move away from hourly billing. And there's three reasons why we think it's important. Number one is that the billable hour is just a absolutely miserable way to work, and it's impacting our mental health. Nobody wants to be measured based on just pure effort. People want to be measured by the actual results that they're achieving. And so the billable hour is just not an effective, healthy way to measure our performance. Number two is that the billable hour incentivizes firms to bill more hours. Surprise! And gives no predictability. So there's a risk of overcompensation. So across thousands of matters, so on PERSUIT, we're an outside counsel engagement platform where clients ask for competitive proposals on an AFA basis. But the client also has the ability to ask for hourly rates as well. But when we look at our data, we see that there's on average a 37% difference between the final agreed price for a particular matter and the average price for the same matter. That's a massive spread. And so what does that tell you? It tells you that there's a huge gap and difference between what any firm might charge you depending on how experienced they are with the matter, and their level of efficiency. And so if you're not asking for an alternative fee arrangement, right, you have a significant risk of overpaying for any matter that you're engaging on. The third reason why it's really critical to get an alternative fee arrangement is that you might actually be undercompensating your firms in those instances where value is critically important. Sometimes you actually want to pay a premium to obtain a high value outcome and to get the absolute best lawyer in the world for a particular outcome. And in those instances, actually just paying on a billable hour basis for maybe a relatively short duration project is a poor incentive structure to being able to retain the most skilled person for that particular job. So those are all, I think, really important things to keep in mind for why we need to move away from the billable hour. And I want to get Ryan from Stryker's some thoughts on why we should move away from alternative fee arrangements as well. But just before I do, just want to call out a couple bullets here on the pros and cons of alternative fee arrangements. The pros really cost predictability. So if you have a fixed fee for the matter, you have much more predictability than just firms billing against a budget that they can easily exceed. So cost predictability stands out as a really key benefit. You're able to pay for the deliverables rather than the effort. So you're agreeing at the outset, what do we want to pay for? And then that price can be fixed. So it's all about paying for specific deliverables, paying for specific value rather than just effort. And as the firms get more efficient with their matters, they can pass those efficiency gains back to you as a client in the form of a lower fixed fee. There's no real incentive to get more efficient if you're on an hourly rate basis. But the cons are really that the firms, there is a bit of a change in behavior in terms of adjusting to a new way of billing for alternative fee arrangements. And hourly rates are just familiar, right? So with an hourly rate, you don't have to do a lot of scoping up front. You can just tell the firms to get started and and they can just start working and start billing you. So there's the con of an AFA compared to rates is that there's just speed to engagement. But for a number of reasons, you can mitigate that risk by putting in place some processes up front to be able to drive more alternative fee arrangements. So I'll stop there and get Ryan. I'm curious to get your thoughts on whether your preference is alternative fee arrangements versus rates and kind of what you think the pros and cons are.
Yeah, for sure. Thanks, David, and thanks to everyone for having me today. I'll take it back a little bit historically. So I'm coming on my third year at Stryker in this role in legal operations, and when I came on board, we had virtually no AFAs in place. In fact, I think I did a benchmarking survey very early on in my tenure here, and when it came to the question on AFAs, we were in the very low single digits on percentage of matters on AFAs. So, fast forward just a little bit, pretty early on, we got hit with the pandemic, and there was, a push from our businesses to obviously look at our costs, for our attorneys to be good stewards of their money, to have a little bit more predictability into what the spend is going to be because budgets were tight. So we made an effort to drive more AFAs for that reason. And we also started the RFP process, which is something we historically had not really done. So we like AFAs. We support those. Largely, our finance partners really appreciate the cost predictability, to have clear visibility into what they are going to have to pay for a particular matter. We've had, and even very recently, we've had very unexpected matters that have arose with costs that different divisions or regions of our business were not expecting. And had we had an AFA in place and they had a little bit more predictability, may not have had such a big issue. So that's the first thing, is the cost predictability is really important to us. The second thing, and this is me being a little bit selfish here as a legal ops professional, it is an administrative burden on me to go through the hourly rates. Every year in October, all of my law firms, and we are a very large company, we have a large panel of firms that we use. We go through the annual rate increase process, and I will be very transparent in saying that I do not like that process. It is a lot of administrative work to go through review the request, take a look at historical data, look at what are the hours billed, what's my effective increase in rate if I grant these increases. The negotiation process is just a lot of back and forth of no, this percent, but it's very inefficient. And honestly, it's one of the things about my job that I really dislike. So the administrative burden of just managing hourly rates, we don't like. And then you add on top of that on the e-billing portion. So all of the rate approvals and things to our e-billing system, our attorneys who have to review all of the line items, the amount of time we spent pulling data from our e-billing system and looking at how much time did we spend for this motion, was that reasonable, was it not? I mean, we could have had an AFA in place, something ahead of time that we knew we were paying this set of money on this outcome, and we wouldn't have had to go through any of that analysis. So it's a huge administrative burden lift off of both my plate, our in-house counsel's plate, and that has been a huge benefit by moving more of our matters to AFAs.
Awesome. Yeah, really great insights there. Just adding on to that, Ryan, in terms of what you said about the having to look at your hourly invoice data to figure out, like, did we have a motion to dismiss in this matter? Oftentimes clients have told me, yeah, like I have thousands and thousands of line items worth of hours. I can't even tell you how many depositions took place in the matter, right? So it just seems really odd that you could have so much information yet know so little about your matter. And so interesting that as we hear clients moving more towards AFAs, they actually have a better grasp on the major cost driving activities that are taking place in those matters. I want to throw over to Maddie just to kind of take us through this next, maybe a question from the audience.
Yeah, we have a question from the audience, David. It's AFAs are heavily talked about, but why do you think they haven't properly hit the mainstream yet? And what practical action have you taken to help corporate legal departments adopt AFAs with their outside counsel? I mean, maybe David, you could begin with that one.
Yeah, so why haven't they hit the mainstream? And so so it's interesting, there's often this perception from clients that they think that the firms are going to be resistant to alternative fee arrangements and that it's going to be a big change management hurdle. But then what we've found is that whenever clients actually ask firms for alternative fee arrangements, the firms are completely ready. They have pricing specialists. They can come in and give a fixed fee right away for any matter that you ask on an AFA for. And so the reality of it is that if the clients ask for it, the firms will provide it. And so it's really on the firms to ask for it more consistently. And what I've found that the reason why clients are actually, despite what they say about wanting to do more alternative fee arrangements, is that they're actually scared of implementing them. They're scared because they think that if the scope changes, then it's going to be a huge burden to have to renegotiate the price. And so one of the things we want to cover later on is what can you do to reduce that burden that might arise with the scope and change? Like how can we account for any scope changes up front to really simplify that process? And by simplifying that process, I think we've helped clients to feel more comfortable with driving more alternative fee arrangements. Laura, Ryan, I don't know if you have anything to add on that in terms of what you think, what are some actions that have helped the lawyers that you've worked with to get more comfortable with driving more AFAs?
I can go first. Sorry, Laura, didn't mean to cut you off. No, I mean, I'd say, yeah, it's a big change management. Change management is such a huge thing that we do in legal operations. So I think lawyers tend to be a little bit set in their ways. So change management can be difficult at times to move away from the norm and move into something different. But for us, as we rolled out new processes related to RFPs and driving AFAs, which is something, as I said, we hadn't done it historically. We really got started really kind of towards the beginning of the pandemic, just a couple of years ago. It was a lot of trial and error with different matters and different AFA types, which we'll go through in the session, and finding what worked for us and really just championing those early adopters of a case study where it went really well, and just kind of sharing the message across our department. Our communication strategy was really important to us when rolling out RFPs and AFAs, and just sharing the message of how successful it was. So for us, it was just a lot of change management, but really just relying on those individuals who were kind of our early champions of driving this.
Yeah, and just to add to that, Ryan, I think that a lot of lawyers are still relatively new to the idea of scoping out their matters and what's involved in actually negotiating a good AFA. And if they're not confident in what is the right AFA for the matter or how to scope out their matters, then it kind of makes them a little reluctant to jump into that world, and they're more comfortable with an hourly rate that just means that they can be billed whatever the firm needs to do. And we talk about that a little bit more throughout the session.
So we have another question from the audience, I think that really relates to this, David. How do you set up AFAs that are completely unconnected to billable hours? Maybe Laura, you could help us with that.
Yeah, happy to help, Maddie. So typically with AFAs, we see three families of them. So they vary in terms of cost efficiency, predictability, and control. So those are the three kind of hallmarks for me in terms of what makes a good AFA. And there isn't really a one-size-fits-all. There isn't really a matter that I've seen where you can't get some kind of AFA or some kind of cost containment. The most common AFA is probably like the first in terms of dipping your toe in the pond of AFAs, and that's a capped fee. So I'll talk about a capped fee a bit more in a moment, but that's really where you're still using time-based billing as the key cost driver, but you're adding some containment in there and making it a little more efficient. Then we've got the family of fixed fees. So those are the things that people usually think about when they think about an AFA. A misconception there is that we just fix the fee for the entire matter and then expect the firm to bill us that at the end, no matter what happens. And that's not the case. There are different types of fixed fees and different types of mechanisms that go along with those to make sure that those are a successful fee arrangement. And then we've got our value-based fees as well, and the goal of value-based fees is really to drive or incentivize the firm to deliver a specific outcome, usually the outcome that the client deems as a successful outcome in the matter. So that's where you've got your contingency fees, where you might be paying the firm a percentage of the amount recovered, a success bonus, for example, for settling a matter early. And these fees usually also are used in hybrid with other AFAs like fixed fees and capped fees as well.
So I might just jump in. Oh, sorry, interrupt. Another question from the audience, Laura, that I think relates to this is, what's the best practice for selecting the most appropriate AFA?
Yeah, so like I said, there's no one size fits all. The best place to start is scoping out your matter and understanding what it is, what are your objectives for this specific matter. Is it a particular outcome? Is it an early settlement? So understanding what it is that you want the law firm or the service that you want them to provide is the first step in selecting an AFA, and then the fee structure comes second to that. So the first fee type that we have that I spoke about before, which is the most common fee type, is your capped fees. So that's where you're agreeing on a budget with your firms, your clients and your firms are agreeing on a budget, and then they put a cap on that budget. So what that means is that the firm can bill anything up to a cap, and then once they start billing over that cap, they basically eat the rest of the fees billed for that matter. So most commonly we see capped fees are successful when the cap is actually at the phase level. So to take a litigation, for example, each phase of the matter would have a specific capped fee, and you might have smaller budgets within that phase for particular activities, but ultimately the firm can only bill up to a certain amount for that phase of the matter. So they maintain the traditional billing model, so your firms are still billing by the hour, but they offer some cost containment and control to the client. So obviously the pros there is that everyone's familiar with hourly rates, and it seems like you're getting a little bit more control in that sense, but the con is that the firm is really taking on 100% of the risk in this particular fee arrangement. So it means that if they're taking on 100% of the risk, they're more likely to increase the cap at the outset anyway, which means that they'll probably never hit it, which means that you're probably just back to your budget estimates anyway. So you think you're getting a capped fee, but really you're just back to hourly billing. So if the firm hits a cap for reasons outside of their control, like the actual work that's required changes, or one of the phases blows out because there's more witnesses or there's more documents to review, then you might be losing quality in that work, because that work will need to go to more junior staff members, for example, so that they can save on those costs that they aren't able to bill you. Sometimes I've seen that firms will agree to a cap and then they'll come back and say, well, can I have some fluidity among the phases, so that if I don't use all my build time in one phase, can I carry that over to another phase? So that actually just defeats the purpose of a phase-based cap in the first place, because then you're not getting those savings in a particular phase, and then there is no real limitation, because if the case doesn't go to trial, then they'll never hit that cap anyway, so you'll just get billed at a normal hourly rate. Obviously, there are things that we can do with a capped fee to mitigate those cons, but Ryan, I'm interested to hear what your insights are on capped fees, because I know you work with these quite frequently over at Stryker.
Yeah, this is one that we've used quite a bit, primarily in the litigation space. Part of our change management efforts actually was a bit of a stepping stone for us to kind of get our foot in the water for AFAs. We kind of started with some of our attorneys who were maybe a bit unfamiliar with AFAs. We first maybe started with some budget estimates, and then we moved on to cap fees, and now we're using this quite a bit in, like I said, in the litigation space, and we are doing phased cap fees. One reason a few reasons we like this. It does give us a bit of the predictability. If we were to bill up to the cap, this is kind of what we can expect over the lifetime of the matter that we would pay. It still gives us the flexibility of billing in a way that we're familiar with, which is the hourly billing. But also, as we've embarked on doing RFPs, we've been able to add in the competitive piece, so we can still drive savings and really still obtain what we believe to be the true market price for different pieces of the litigation by making it competitive. So even with a cap fee, we can still have our firms, compete and see where they stack up against the competition and putting forth their caps. And then obviously, if and that does help, I think, with the firm setting a high cap, because early on with this, we saw some firms were probably giving us a bit of a high cap, but as the competitive process went on, we saw that the caps lowered. But as the billing occurs, and we kind of do a look back at. We manage this in our e-billing system. When we do a look back, we can see that there's additional savings by not getting the cap. So it was a good way for us to kind of get started into the AFA landscape. So it was one that really worked well for us.
Yeah, still a really good place to start. And one of the ways that we see clients also mitigate that or address that risk that the firm takes on is by still giving the firm the opportunity or the flexibility to increase the cap if they really are required to do more work. So if the assumptions that you established at the outset of the matter change significantly, then if those numbers of assumptions change, then that should be grounds to increase the cap. So having a mechanism or a tool in place to address material deviations in scope is a good way to make sure that the firm is not taking on too much risk so that they can't set a reasonable cap. And then that competitive piece, running a competitive RFP process, is the best way to really ensure that you're getting a good capped fee arrangement as well.
So great stuff on the cap fees. The other approach is just a pure matter fixed fee. So this is where you're just saying, so on the last graphic, we had the money stacking up, and then once it crosses a threshold, it's burned, so the firm has to eat all the overage. With a fixed fee, it doesn't really work like that. There's no accumulation of billable hours. the price that you agreed is locked, put it in the safe, it doesn't change. Unless there's material deviation in the assumptions we've made, the price that we agree to for that matter of fact fixed fee is completely locked in. So this completely takes the billable rate, the hourly rate, out of the equation. Once you have a fixed fee, the hourly rate doesn't matter, the number of hours billed doesn't matter, the price has been agreed. So it gives you even more predictability than a cap fee in that sense. The cons are, though, the client now does bear some risk of overpaying because if the firm does bills less hours. On a cap fee, the client would pay less. Now with a fixed fee, that price is locked in, so it's more of a risk sharing matter. Fixed fees are more client firm share the risk because the number of hours aren't going to dictate the price that you pay. So you need to have a really clear scope of work and assumptions up front in order to have a total price that's locked in. And so for those matters that have phases, some of which may not occur, we don't recommend a whole total flat fee for the matter, right? We'd recommend that you break it out by phase. But if the project is singular in scope and you know that the phases are all going to happen, then just ask for one total price for the matter. So this works really, really well, for instance, with like a legal advice project where you're saying, hey, do some research, provide a deliverable. Maybe that deliverable is a negotiation of some sort. Maybe the deliverable is just a report or a presentation. So it's just some sort of advice project. Those tend to lend themselves really well to just total matter fixed fees. The next fixed fee or the next alternative fee arrangement also in the fixed fee family is a portfolio fixed fee. So just like the matter fixed fee, you've got the money, put it in the safe. That's how much you're going to pay, regardless of the amount billed, the amount of hours billed. But now we're taking that price per matter, and we're actually going to bundle up a number of matters into one portfolio and ask for a total price for that entire portfolio of work. So that's where you can see that graphic. You've got a bundle of a number of matters, one total price for the entire portfolio, and that fee is locked unless there's a material deviation. And maybe we're using a material deviation clause that says we're going to pay this price for this entire portfolio unless there's, let's say, a 20% change in the number of matters assumed, right? So we can kind of taking this to a higher level and saying, we're going to assume, let's say there's 50 personal injury matters in this portfolio. Give me a fixed fee for 50 personal injury matters, plus or minus 5 or plus or minus 10. And as long as you've had that many matters, this is the price that I'm going to pay. So it gives you really high level annual budget predictability for that entire portfolio, which is good. And it gets away from frequent monitoring of small tasks because you've kind of elevated above and said, here's what I'm going to pay for this entire portfolio. But the cons are that could be a little bit too much risk to bear. If you have a lot of matters that are significantly different in scope, then it's pretty difficult to kind of just ask for a total portfolio fixed fee without getting into really clear assumptions as to what's going to be involved in each of those matters. So you have to actually provide a lot more data up front to the firms in order to negotiate a portfolio fixed fee, which is, it might still be a good approach, but if you don't have the data and you don't have those assumptions in terms of the amount of work required, then it's really difficult to do that. One area we've seen this be really interesting is an e-discovery portfolio. So you can see a screenshot there on the right. Sometimes clients can ask their law firm, their e-discovery vendors, actually give me a total annual all-in fixed fee to handle all of our e-discovery work across all jurisdictions in a calendar year. And they'll give the vendors a number of assumptions about the number of matters, the number of documents, the number of terabytes in scope of review in various jurisdictions. And then the vendors come in and give an all-in fixed fee to handle that work. And you can even break out that all-in fixed fee into like multiple lots to say, what about if we just gave you 50% of the work? Give me a fee if we only gave you 20% of the work. And so that's a really good way to kind of mix and match and say, I'm going to give one vendor 50% and I'm going to give another vendor 50% of the work. And I have an all-in fixed fee for that entire portfolio. Ryan, have you leveraged any portfolio fixed fees? Curious to get your thoughts on where you think this works really well.
We're just getting started with portfolio fixed fees. We actually recently did an RFP for a portfolio fixed fee, so not in e-discovery. So we actually leveraged it in our investigations practice group. So we had an investigation in a particular region where it was hourly billing and the cost were very high, and finance in that particular region raised some red flags, and that led us to do an RFP for a new matter that was coming up. So we decided to do a portfolio RFP where we broke out investigations by different complexities and by different region. And we had a really good list of scope and assumptions to take in, and when comparing what we had paid hourly to the new fixed fee we obtained in the RFP, I mean, it was very encouraging. Our finance leaders are very happy with the result from it. So now we have predictability. We have a great scale of, if the investigation falls within this type of complexity, we know the cost up front. We got a great result. Now we have a preferred firm that's able to handle it for us. So it just, it's kind of our first dive into the portfolio fixed fee landscape, but it was a really good result.
Awesome.
I think I might just insert a question from the audience, because we've been getting quite a few questions around how you handle scoping this. So one of the great ones was, what types of projects best lend themselves to AFAs versus others that might not? How do you handle scoping a project that has several unknowns? And what recourse if the scoping changes midstream? Laura, can you help us with that one as well?
Yes, it's the most popular question that we get. So when we say scoping out your matter, we're not asking you to predict everything that might take place in the course of a specific matter or the trajectory of the matter. So typically what we say is identify the 4 or 5 key cost driving activities. What are the activities that the firm is performing that will end up ultimately driving the most cost? So that might be in a litigation, for example, the number of witnesses, the amount of discovery that's required, whether there's a trial, the number of trial days. Those are the things that generally drive costs. So we're getting away from that time. For a transaction, it might be number of parties, number of primary agreements, things that you can usually identify on a term sheet. So if you can scope out all of the things that may take place in a matter, just at that level of what is driving costs, and then provide assumptions with those, then you can usually go out to the firm and ask them for an alternative fee arrangement on that basis. So to use these phase level fixed fees as an example, and you can see how this might apply in a commercial litigation, what you're saying to the firms is, give me a fixed fee for the matter, but break out that fixed fee by each phase. And so I'm going to pay for those phases as and when they occur, so that if the matter settles early or it doesn't go to trial, I'm only paying for the work that you've actually done. Within those phases, I'm going to identify those key cost driving activities, and I'm going to quantify them. So I'm going to say up front how many witnesses there are, how many documents need to be reviewed, how many trial days there are, for example. And so the firm is giving me a cost for the phase based on those assumptions. If those assumptions change at any time throughout the matter, then what I do is I look at the key cost driving activity that's actually changed, and by asking the firm for that fixed fee at the phase level, and sometimes even further by activity, I can have a really clear understanding of how much that price should change. So it doesn't mean every time they send a fax or every time they have an extra phone call with me, they're going to tell me that the key cost driver activity has changed and we need to change costs. It's just those 4 or 5 things that you identified at the outset of the matter. And the rest of that, the firm bakes into the risk of their fixed fee at the phase level. So the goal when you're scoping out your matters is not necessarily to get those numbers right or get those assumptions right based on the facts. It's to give each of your firms a set of assumptions and some parameters so that they're providing a fee that is apples to apples with their peer firms. So you just want to make sure that you're able to compare those fees across the same set of facts. And then with the right material deviation mechanism in place, then you can have some of the cost control. So when that discussion does come up, the onus is on the firm to say, well, we thought there would be this many witnesses, there's now this many. And so looking at our costs for those witness interviews, we know exactly how much the cost should be increased by. So Ryan, keen to get your thoughts on this. I know you've used phase-based fixed fees before. Have you been in a situation where you've needed to go back to that initial proposal and talk to the firm about a change in price as a result of a significant deviation in the scope of work?
Yeah, so phase fixed fees are starting to become the preferred AFA type for us, especially in the commercial and employment litigation space. We kind of, like I mentioned before, we kind of got started doing a lot of cap fees. Well, first budget estimates, then moved on to cap fees, and now phase fixed fees. One of the reasons we really like this is, again, the predictability, the ease of billing, eliminating the invoice review portion of it. With the cap fees, we have to set up our e-billing system to monitor the fees that are coming in and have it cut off at the caps. With this, we just know ahead of time what it's going to be. The other thing too is, we like to obtain all the pricing ahead of time, but oftentimes we kind of know up front, like this is kind of a frivolous case. It's probably going to settle or be dismissed early. So we now know that we're only going to pay for the phases that the firm actually engages in, which is included in RFPs. So, if we only get through the kind of initial phases of it, we know that's the total we're going to pay. So, yeah, and I'd echo what you said about the, one lesson learned from us as we've kind of embarked on this journey is really doing our best to scope out the matter and really just putting assumptions in for our firms. We haven't had a lot of situations actually where we've had to go back and revisit the assumptions that we laid out because, let's say, there were 4 witness interviews and it was then 10 and we need to adjust, pricing based on that. We've actually been able to do a good job of putting pretty accurate assumptions in place. So fortunately, we haven't really encountered a lot of that, but we've had a couple situations where scope has changed and, we really value the relationships with our law firms. We see them as partners and extensions of our department. So we always engage in an open dialogue with them if the scope changes, and we've been able to come to mutually agreeable, results. And oftentimes, the firms, because they're great partners of ours, they've been able to write off time for us. So there's a cost savings there. They may have had to do a little bit of additional work, but as a courtesy to us, they've been able to do that. So this is slowly becoming kind of our go-to AFA model type for a lot of, as I said, a lot of our litigation work.
And there is a process of refinement there in the RFP phase as well. If you're not particularly sure what the assumptions should be, if you find that there are phases that are too broad or you are not completely sure what work the firm needs to perform in that phase, then in the RFP process, you can go out to your firms and say, this is what I think it is, but I welcome any suggestions on the assumptions, any additional items, and then you go through a process of clarification and refinement with your firms before you make a final evaluation on their proposals. So you take all of the information. Some of them may have different strategies or different things, different nuances, or an incumbent firm might know more about the particular matter. So you take their suggestions and their assumptions, and you release a standardized set to your firm to say, here is what we're going to go with. Give us a phase level fixed fee. So that is one way to mitigate matters where scoping the particular phases or the assumptions is quite difficult or ambiguous.
Just a couple of questions there on how we define phase. It'd be great if, David, you could give us a little bit of background around that.
On how we define the phases? Is that?
Yeah. So is it related to like a billing system phase, or is it purely to do with litigation, or like when we say phase, what are we meaning?
So it's totally, I mean, it does vary in terms of, sometimes clients will break up discovery into multiple phases because discovery can be so big that it might be good to break that out and to say, let's have a phase for just expert depositions and reports. Let's have a separate phase for fact witness discovery. So you can absolutely there's no, I guess, I think what I would steer away from is just saying L100, L200, L300, and just using the UTBMS code sets to define your phases, mainly because there's just way too much overlap in what could be considered part of L100 versus L400 versus L5. So what we recommend is just to focus on defining the phases based on the actual deliverables required in those phases. And as long as you're clear on what deliverables are required, then you can't really go wrong in terms of how you break it out. So that's what would be my recommendation. I don't know, Ryan, if you...
Yeah, no, I just wanted to add on to that. For the fixed fees, I agree with that. If you are using cap fees, we have found it to be beneficial to align to the L codes, because at least our e-billing system, and I imagine a lot of the others out there, have mechanisms in place where we can set caps based on the codes so that the system will monitor the progress of the work. So as the law firm bills, so we've been able to set that up, and it takes away a lot of the sort of manual oversight of, are they approaching the cap, are they not? The system will just do that for us. So for us, with the cap fees that we discussed earlier, aligning the RFP to the L codes has actually been beneficial.
I might just, just skip ahead to this other. We had a slide here, just because you mentioned about invoicing. That cap, I think the third option down here is the one you just spoke to, Ryan, in terms of setting caps by UTBMS code or by L code by phase. That's a great approach with the cap fees, absolutely. With fixed fees, sometimes, just to avoid the problem that I was referring to in terms of there being maybe some overlap in terms of activities that may overlap between phases, a lot of our clients have started to create custom task codes for various phases, just so that if you modify and say, hey, like we want a specific fixed fee for early case assessment, they can instruct their firms to bill with a custom task code for that early case assessment. So we provided, and these slides are available to everyone, so I won't go into too much detail here. But there are a variety of ways to kind of start to bill in a different way. There's also single line item invoicing. So if you have, let's say, a matter for $100,000, you can divide that by 12, or if the duration's 10 months, let's say, just for easy math, divide it by 10, and then have the firm bill you a single line item invoice of $10,000 per month, rather than reviewing thousands of line items with the billing data. It kind of streamlines and simplifies the invoice review process. But obviously that is a change in behavior and a bit of a change in management step to kind of move towards single line item invoices and away from the traditional e-billing process of billing by UTBMS code. I'm going to jump back over to, there's just a couple more fee types, and this next one I think is important because we had a question from the audience about how do you negotiate AFAs for intellectual property work, and this is one where we've helped clients to put in place a fixed fee menu. So like think about it like you go to a restaurant, you have a menu. Basically, you only pay for what you eat. You only pay for what you order. So you can put in place a menu of fixed fees or a service list where you've pre-agreed upfront for all the work that happens over the next 2 years. What's the fixed fee that the firm's going to charge me anytime I do this service? So you can think about it in terms of like for immigration work, let's say, every time I have a firm do an H-1B visa filing for me, it's going to be a fixed fee of $3,000. Like that's not really something that you should have to renegotiate every time someone does a visa filing. It's too small. It's really high volume and really low spend. And for those types of matters where it's really high volume, low spend, we'd rather negotiate not at the matter level, but really across the entire portfolio of work and put in place this pre-agreed menu of fees. And so for patent filings, for instance, trademark filings, renewals, patent renewals, office actions, those are services that are happening all over the globe. And so it's really difficult to try to negotiate those every time a new matter comes in. And so we've helped clients to put in place a fixed fee menu for those types of IP services. So hopefully that helps answer that question in terms of the best AFA approach for IP services. Moving to the last fee type that we have in the slides is the success bonus. So Laura, I don't know if you want to speak to how the success bonus works.
Yeah, absolutely. So The success bonus is another fee type in the value-based fee family. So it's a good way to incentivize your firms to deliver a successful outcome. So very similar to a contingency fee where you're paying the firm a percentage of what they recover. A success bonus is basically an additional fee that you give the firm if they achieve usually what is an earlier outcome for you, a really efficient outcome for you. So this is a really good opportunity. Pairing this fee with another AFA, like a fixed or a capped fee, particularly in litigation, is a really good way to make sure that you and your firms are aligned on what you actually deem as a successful outcome, because this is something that a lot of in-house counsel don't often think about at the outset of the matter. They don't often think about aligning expectations and having that discussion up front. And sometimes that can be a contentious discussion if you don't agree on what is a successful outcome. But it is important to uncover what you both agree is the plan moving forward. So obviously the pro of a success bonus is to incentivize or motivate your firms to achieve the best result for you, despite any loss in what would normally be billable time if they achieved an early outcome for you. The con here is, I guess, why should you have to pay your firms a success fee for doing their job or for achieving the outcome, which is a valid point, and why these fees typically work best with other fee types and other fee models. So Ryan, have you used success bonuses, whether they're on their own or in hybrid with another fee type before?
Yeah, just a couple quick thoughts, because I know we're getting close to the hour and I want to make sure there's tons of questions coming in. We've really only used this in our M&A space. It's a little bit new for us, but we've been able to leverage it in M&A. So success bonus if a deal closes has been a good way to obviously incentivize firms, and obviously we obtained a good result, but we're happy to pay that. The deal is closed. But on the flip side, we're also looking and asking our firms in our RFP process to what kind of broken deal discount could you give us if the deal doesn't go through, if it falls apart. So having that be part of the RFP process. So again, another area that we're kind of just getting started in, but the early findings are that it's been working well for us. Really in the M&A space, we haven't yet kind of branched out into the other practice areas for this AFA type, but in that space, it's working well.
Thanks, Ryan. Back to you, Maddie.
Thank you. We've had some great questions come through. I think the question I'll start with, because there's a few in different forms, has been around law firm pushback to using AFAs. I think it was encapsulated really well when someone asked, what leverage do we have in negotiating AFAs during the current legal landscape when there's a shortage of attorneys and even the law firms are finding that their lawyers are overtaxed and not able to handle workloads? It seems the clients do not have leverage at this time. Ryan, maybe you can start with this one.
Hold on, you went really fast with that one.
Sorry.
Can you repeat it?
What leverage? Sorry, that's my fault. What leverage do in-house teams have in pushing for AFAs in this current legal landscape where attorneys are overworked at the moment and there's a shortage at law firms?
Yeah, that's a great question, actually. And we're finding that in our annual rate review process, it's been a little bit different than years past because of a lot of those reasons of, our firms they've had to make adjustments to keep talent. We're facing a lot of the same issues with talent. You hear the whole great resignation going on right now. The legal market, there's a lot of fight for talent. So I would say for us, what's worked well is that we have this RFP process in place, that we're not sourcing just one firm. We're going to a panel of firms, and some firms respond to RFPs that they don't have capacity for the type of work, and that's fine because we have other alternatives. We have other firms on the panel that may have capacity that can do the work for us. So for us, it's been great to have this RFP process in place because we can go to 3, 4, 5 really good partner firms of ours and find the right fit for us. I think there's great cost savings ability into going through this type of a process. But for us, the number one goal of doing this is finding the right firm for Stryker that's going to give us the best result. And going through the RFP process really helps us achieve that. So in this competitive market, the RFP process has been able to help us find those firms that have the bandwidth, have the right experience, have the right attorneys that can achieve those results for us.
Yeah, I think that leads really nicely onto another question that we had from a law firm attendee. How do you begin when a client, so the in-house team, has a fixed mindset on how they want to pay fees?
And that one's for me?
I think so.
Yes. Okay. So, I would say, from my seat, we are looking for our law firms to partner with us. We are looking for vendors who understand our goals and objectives, and we clearly lay those out in the RFP process of this is what we're looking for. It may not be price. It may be something totally different from price. It may be we're really interested in your experience in this venue or your experience with opposing counsel if it's litigation, whatever it is. So we've made it very important to us to lay out our goals in the RFP process, and we want firms that are willing to partner with us for that. So if we are asking for an AFA, we want our firms to provide us with an AFA. We've actually had situations where a firm has come back in an RFP where we've asked for AFAs and they gave us an hourly rate and we just immediately eliminated them from contention. Because if we're, again, as I said, if we're looking for a partner and if someone's not willing to go above and beyond to give us the result we want, we'll find someone who will.
Yeah, that's really helpful. I mean, David, did you have anything to add to that?
Yeah, so I would just say what I'd recommend for firms that are participating in the RFP process is, further to Ryan's point, if the client asks for, let's say, pricing broken down by phase for fixed fees, give the client what they want. But if you want to provide an alternative option, then provide that alternative option, but don't do it. Don't disrupt the structure that they're asking for. Give the pricing the structure they ask for, and then say, hey, by the way, we can also do this other approach, and maybe provide that as a secondary option in the RFP. But it's nothing's more frustrating for a client than having to deal with a complete lack of apples to apples proposals because firms didn't follow instructions.
That's a good point, David. We actually have had a couple RFPs where a firm has come forward with, they gave us what we had asked for, but they also in the RFP gave us an alternative. We've had situations where our attorneys really because law firms can be innovative. They came up with some really innovative, interesting fee structures, and our attorneys really liked what they came forward with. So that has worked as well. So we do also appreciate when firms come up with other solutions as well and innovate, as long as they're kind of responding to what we had set out for. But yeah, I totally echo your point that we really like when we see that.
Yeah, I think the emphasis on partnership and creative sharing is really important for the RFP process. Laura, I have a question for you. So it's quite a long one. I personally believe the biggest benefit of AFAs combined with RFPs is a better legal outcome. I think most people in legal ops think cost saving is the biggest benefit. I think lawyers are and should be most interested in the legal outcome. So the question is, how do you get legal ops people to understand that the biggest benefit is also what most attorneys or lawyers are actually interested in?
I think it's interesting that this question starts with the assumption that AFAs do result in better legal outcomes, because that's true, but there's a misconception around whether or not they actually do result in better legal outcomes. Ultimately, AFAs incentivize firms to deliver more efficient results, and they require that expectations are set up front. They can be measured by a competitive AFA process. And they don't actually come at the cost of quality, which is the misconception around AFAs. So all of these things actually equal better legal outcomes, and ultimately better legal outcomes usually save money as well. So if your firms are getting, if a case is settled early because of that firm's unique skill set or experience with the subject matter, then that's a saving. So better legal outcomes are still synonymous with saving money. And I'd say that legal ops teams, particularly the legal ops teams that I work with, are very receptive and understand that there are a number of criteria that go into selecting a firm for a matter, and price is usually only just one of 3 or 4 areas where you're assessing your firms. So we help clients build AFAs, but we also put a lot of emphasis on using the RFP process to uncover who is actually the best firm for not just this practice area, but for this specific matter and the facts associated with this specific matter. So things like asking really strategic and targeted questions of your firms, and the assumption and clarification process associated with an AFA are really great tools to uncover which firm is actually probably most likely to deliver the best outcome. So again, better legal outcomes are synonymous with savings as well, but savings is not the only thing that we're looking at when we're looking at engaging firms. And I think legal ops departments are well aware of that, and they very much do place emphasis on other areas of the relationship and the engagement.
Yeah, I know that we've only got 4 minutes left and we've had some great questions come through, so I'll include our contact details at the end for you to send through any questions that we didn't answer. But we've had a couple of groups of questions around how do you measure the value of an AFA? What's our opinion of shadow invoicing, and how do you know that you got a good deal? David, do you want to start with that one?
Yeah, and I noticed there's also similarly related questions around how is there an administrative benefit to an AFAs if we're still using, do clients who work with PERSUIT still require hourly reporting from law firms? So it's a really good question. What I always recommend is that when you have a fixed fee, that you do not ask for a shadow bill, and that you really just focus on what's the price that's been agreed. That's the price that I'm going to pay. What's the measure of success? The best measure of success is, did I get the best price that the market could bear at that point in time? So the best AFAs are market-driven AFAs, where you're asking multiple firms for proposals at that point in time for that specific matter, given those same set of assumptions. And if you negotiate the best price you can from the best firm for the matter at that point in time, the difference between the price you agreed to and the market average, that's your measure of savings. So if I paid $100,000 less than the market average, then I saved $100,000, right? I avoided paying $100,000, which was the higher price that the market rate was set at. And so recommend not to look at a shadow bill to determine whether your AFA was successful. The reason being, of course, the billable hour that the firms would provide you in a shadow bill should actually be less than the fixed fee, because a true fixed fee is incentivizing the firms now to be more efficient, to hand more work to more junior resources where appropriate, such that the firm can still profit on the work. So you as the client shouldn't be worried about the firm profiting on the work and the billable hour being less than the fixed fee. Of course, it should be less than the fixed fee. The firm still needs to profit on the work. You're incentivizing that to happen, right? You can't assume that the amount of hours billed in a shadow bill would be the exact same amount that you'd be billed on an hourly rate basis, where the incentive structure was completely different and the firm was incentivized to bill you more hours, right? You can't assume that the behavior is going to be the exact same. And so that's why I really encourage you that you use the market would be an RFP process, like Ryan does at Stryker and like all the other PERSUIT clients do, and use that RFP process to define what's the appropriate price for a particular matter.
Amazing. Thank you so much, David, Ryan, and Laura. And Nicole, I'll hand back to you to wrap up the session for today.
Great. Thank you guys so much. This was an incredible presentation and kind of great tips, great solutions, and giving everyone a better understanding of how they can approach AFAs. So thank you all so much today. Thank you everybody for joining. We're going to send out a link to the recording so you can come back and listen to any tips or tricks that you've heard here. And I will also include a PDF of the handout because I know some of you might have had problems downloading it from the platform. So you can come back and download those as resources. So thank you, and I hope everyone has a great night.
Thank you.
Thank you.
Thanks so much.